ethics OPM. So the second one this morning is on the ethics OPMA and the Public Records Act, and Chris will present this one as well.
And I was unable to open my document earlier this morning. It seems to be cooperating now, so I am hoping that it continues to do so. All right, so presumably you have had some training on these matters. I think I heard that the state and or WAPA and or MRSC all offer training. So these are just little refreshers and some with some particular information about the county. So next slide, please. This is the state ethics statute, RCW chapter 42.23. And you will see provisions that basically come from the statute in our code and in our policies. So I will let you look at that. The first part is basically this: don't do business with the county. If you're a county counselor, you should not be entering into contracts with the county. And often it's not a good idea to do business with others who do business with the county in a way that your actions could be construed as assisting people that you have a financial relationship with. So that's fairly simple in concept. Second, let's talk about nepotism. Don't do it. As simple as that. You cannot be hired in a staff position by the county, and nor should your family and best friend be. We have had some in the past fabulous instances of close friends receiving good staff positions and then some problems. It's risky business. If you have any questions, please ask beforehand. This is not, it's better to do forgiveness. Just the opposite. It's better to talk to folks about what you're thinking, and that would be Kathleen, that would be my office, might be HR, all of the above. Better to mention it to us than to see it on the front page of the Columbian. Information. You will be in a position to receive a great deal of confidential information. And sometimes that will come to you from my office in an email, and it will say attorney-client privileged or work product privileged. Sometimes it will say confidential, attorney-client privileged. And I often put on my emails, and I know Kathleen puts on her emails, please do not reply all. If I had my way, I would remove the reply all function from everybody's computers. It is a problem sometimes, particularly with chain messages. So another email tip is just start a new message. You know, enter the people's names that you want to get your message. Re-enter them. It doesn't take that long. Chain messages can lead to problems when people at the beginning of the chain who have no business having particular confidential information obtain it because of the odious reply all function and, 15 emails that go together.
Chris,
Yeah.
in my full-time job, I work collaboratively with my team via email. And so it's almost second nature to reply to all. That just happens without even thinking about it. What happens in an instance that this happens here at council when we accidentally reply? What steps do we take then to remediate that?
Well, once it's done, it's kind of done. So we'll put it in all caps and bold. Do not reply all.
Right, but
So-
it still doesn't prevent by accidentally.
I will say if I'm on the email, you'll get a nice kind reminder from me not to do it in the future, as some of you have seen. But the other part that could be an issue is with OPMA and
Mhm.
meetings, because there is some regulation about deliberating. It's one thing if you're sharing information, you can't deliberate.
or discuss, or evaluate, or review.
I was just
yes.
going to add too that there is lots of communication that we could reply all to, and it wouldn't be a violation, but it is safe to just avoid it at all costs, because it's sometimes you might think you're doing something benign, that's not a violation. Just don't do it. I know that. And then I can't remember if it was Outlook or Gmail. I think it was Outlook. So I think there's settings in there that you can go that, like, if you're on your mobile device, it defaults to reply all or reply. Make sure it's default to just reply. That was one helpful thing.
That's a good best practice. Thank you.
And I too am likely to respond if I see that there has been a reply to all. Just
You will
know,
hear about it.
Yeah.
just in hopes that it triggers the thought earlier in the process the next time. But I know that everybody is accustomed to say, reply all. Please just don't. Okay, so one of the situations in which you will get confidential information is in an executive session. And I'll talk about this later when I'm talking about OPMA. It is not allowed. It is prohibited by state law. And it's the last bullet point up there for you to reveal information that you have received in executive session. So don't do it. That's if you, again, if you want to know, can I talk to so-and-so about this? Again, ask. We're around. And we will be happy to respond. Okay. Enough about information. I'll talk about that more on OPMA. So Kathleen talked a little bit about receiving goodies because of your position. I worked once with one of the advisory boards and commissions at the county. And in my first meeting, I walked in and there were all these huge, and they were big, gift baskets on the table to the right. And I later found out that these folks were also invited out to a restaurant, all given by the primary person who had business with that advisory committee. Um, so that was an instance of shock and awe, and I advised them not to accept their holiday baskets and told them that they couldn't go out to dinner. So I might have been the Grinch, but I'd like to think that that cleaned things up a little bit and presented then an appearance that the advisory board was not there to do the bidding of their benefactor. Again, think about how it would look on the front page of the Columbian. Every so often in holiday time, I come up to your office on the 6th floor, to the county manager's office, and there in the staff area are like boxes of candy and stuff. Yeah, we might get those. They are, they might be brought in by one of you or somebody on the staff. But if somebody gives a box of candy for the whole office to share, for example, I think that doesn't reach the level of concern. So it requires a little bit of thought about what it is that you're getting, and in general, just don't accept offers of such things. Okay, the
Can I ask a
oh, I'm sorry.
question? So I just took the training, the online training that said you can accept up to $20 twice in a 12 month period. And it wasn't really clear to me how that works with dinners, and especially if you're working with someone talking about work, but they're a friend or not. I just didn't know when it's okay to accept the one person pay the bill and it's not you, or you split the bill. I mean, where's the gray line there?
So looking at that hypothetically is kind of difficult. It would be easier to look at it with a specific question. But in general, if you're talking about county business, then keep it away from receiving a gift. That's my advice.
So that is interesting because Chair Marshall, I don't know if you recall, but when we went through the NEO training, they had said that it was 0, that there was no number that we could accept.
That's my recollection as well. I think there are different rules for state legislators.
That could be it.
Yeah, so
Because
that could be it.
my recollection of the statute involved also says if the county is bigger than 125,000 population, the amount that you can receive is 0. So that is more in keeping with my concept. Again, if you have a question, ask. But if you're talking about county business, my advice is don't accept.
Interesting that the state legislature has different rules.
Oh, they have
Interesting,
different
yeah.
rules
I
and
just went through a training that
Yeah.
was for us. that
Yeah,
said
that's
the
interesting. So
20
I wonder
plus
if
20.
they changed the state law on it. I don't know.
they have
It might be
different
something that we
rules in
reach
a
out to
couple of
WASAC
areas.
about. Because I will say that, I understand 100% the intent of that, the meaning behind that. But I also know that culturally, there are cultural situations where people will be offended if you don't accept a small gift. And it's not that they're trying to buy your vote or anything like that. It's just that's their culture. You know, they enjoy doing that. So it is tough it's tough and uncomfortable to turn things down, which has happened on multiple occasions for me. So it's a sensitive nature. I can see absolutely 100% the intent behind it, but it's tough. Either way, there's pros and cons. If it's 0, if it's 20, or I don't think it should ever be higher.
Should we get some clarification on this, if it is 20 or if it's 0? I think 0 is definitely an easy number to keep track of.
It's an easy number to keep track of, and that way you don't have to mess with, oh, are we going to split this in half, or can I only pay for a third, or, whatever. If you would like to get clarification about it, we can certainly do that.
Yep, thanks.
All right. Contracts. So some of these violations of some of these statutory ethics provisions come with civil liability, fines of up to $500, and going back to the malfeasance concept, they can be grounds for forfeiture of or removal from office. So think about whether it's worth it. It probably isn't. Okay, next slide, please. When you are engaged in campaign season, or when somebody else is engaged in campaign season, or whether when there's a ballot measure on, do not use county computers, printers, phones, supplies of any kind, services of any kind, including mailing services, meeting rooms, Post-it notes, pens. Just make it 100% separate. Disclosure is, if it comes out, is embarrassing both to you and to the county. And again, there are possible repercussions, possible consequences of violating this. So next slide. So once again, this is the friends and family non-employment provision is also in our charter. So that concept has its origins both in state law and in the local, our locally adopted governing document. Next slide, please. So state statute specifically contemplates that some counties are charter counties. Some cities have charters. And state statute says that if the ethics provisions in a charter, if the charter language is more strict than state statutes, then the charter language applies. So it's not an out if the charter says you can't do X, but state statute doesn't prohibit it. It's not an out to say, but I complied with state statute. You might have, but the charter governs in this case. Clark County's charter requires establishment of an ethics review commission. And I believe that was an amendment to the charter. The Ethics Review Commission has been operating since 2022. It's 3 appointed members, and the commission receives, investigates, and rules on complaints with the assistance of the charter office. What's it called? Eh,
County manager office supports the charter
Right,
commission,
right.
and then human resources also is part of the process.
So, yeah, the Ethics Review Commission gets a lot of assistance from staff, and anybody can file an ethics review an ethics complaint. There's a hotline. There's on an online portal, I believe, and anybody can file it about anybody who is an official, an employee, a volunteer, whatever, of the county. And once a complaint is filed, then the ethics review procedures start going into effect. I think there have been somewhere around a dozen or so ethics review complaints since the commission was established. Only one of them has gotten to the point, after some of them after a little bit of investigation, some of them after a little bit more investigation, where the Ethics Review Commission has believed that those complaints were worthy of holding a hearing. So by and large, either the people complained of are not engaging in unethical acts per the findings of the Ethics Review Commission, or the acts that are being complained of are not ethics. So ethics violations. So that that commission continues. Next slide, please.
Just quick question on that one. The appointment process, I don't recall. I mean, it says in conjunction with county council, maybe we did go through that process, but I don't remember it. How
We-
did that appointment process?
Yes, we did interviews. I believe Amber and legal was on with me in the interviews, and then the council approved them during a Tuesday meeting.
Okay, was that when we were on?
I think it was prior to your time.
Okay.
Yeah, it was the end of 2022.
Okay, I was just unsure. I mean, we have so
Yeah.
much stuff go through. It's easy not to recall things like that, but
Yeah.
and I will say also, and I think this is good for the public to hear it. They operate completely separated from us. Like,
Yes.
I honestly have no idea what's happening in the ethics commission. Sometimes I read about something in the newspaper, and that's about it.
All their meetings are online on the county manager
we're not-
website.
We're not held from it, but we're just not a part of that process at all.
Neither am I.
Yeah.
And I will say that because I don't want to, they need to do it. HR supports in a very specific role, but they do run their own.
Yep.
They're
Which is, I
upset.
think, the way it
Yes.
should be.
Absolutely. It is intended to be fully separate from either staff influence from the county manager or council or other elected influence. And I will say that most of the complaints that the commission has received, they have received legal advice from an outside attorney, because for one reason or another, if somebody files an ethics complaint about the prosecutor, I can't be involved in advising the commission what to do with that complaint. The prosecutor is my boss. So I would have a great big enormous conflict of interest. And in most cases, there is a conflict of interest with the prosecuting attorney's office. If, there's a complaint about some staff member in a department, well, often that staff member is engaged in some activity about which they've received advice from the prosecutor's office. So we go to outside counsel for that. Mr. Golick does a special deputization of an attorney who is not employed by the county in any way. So they're a contractor. All right, where are we? Yes, thank you. So these are the ethics. This is one of the ethics code provisions that was adopted following the amendment of the charter about this. And you'll see that it refers to the statute that we've been talking about, and it also refers to our human relations policy 13.1, which primarily addresses conduct of county staff and, says a lot of the same, has a lot of the same prohibitions and requirements that are applicable to you. The head of X department should not be hiring their 6 nieces and nephews for important positions or even necessarily unimportant positions. They shouldn't be contracting with their family, their friends, whatever. So, next slide, please. Ethics Review and Oversight Office. That's what I was intending to say. And that's generally, we take that to mean the folks in the county manager's office, both of whom are sitting across from me, who monitor the complaint line and communicate and schedule meetings and so forth. So, I believe that's all I have on ethics. If any of you have any further questions on ethics, I would be happy to address them.
Looks like we're good.
Okay. On to OPMA. So I am going to read a slightly abbreviated version of section 42.30.010, which is the statement of purpose for the Open Public Meetings Act. Before I start, the OPMA was adopted in 1971. It's been around for a while. And it was adopted at the same time as a number of other, say, reformist pieces of legislation were adopted either by the legislature after initiative or after a lot of public input and sometimes outcry. So this is where it comes from. So here we go. The legislature finds and declares that all public councils, offices, and all public agencies of this state and subdivisions thereof exist to aid in the conduct of the people's business. It is the intent of this chapter that their actions be taken openly and that their deliberations be conducted openly. So the people of the state do not yield their sovereignty to the agencies which serve them. The people, in delegating authority, do not give their public servants the right to decide what is good for the people to know and what is not good for them to know. And the Washington Court of Appeals has said about that, the statutory purpose statement employs some of the strongest language used in any legislation. And that was a Court of Appeals case that arose out of the Battleground School District more than 20 years ago. So that's the general idea behind it. all meetings of the council must be open and public, and outside an open public meeting, a quorum of the council cannot take an action except when there is some statutory exception to the OPMA. So I just used a couple of loaded words there. What is a meeting and what is an action? The definitions in the OPMA are pretty important. Meeting, the definition of a meeting is a very unsatisfactory piece of language. It's defined circularly. A meeting means meetings at which action is taken. So now we all know that's what the statute says. In general, we can think of it as a quorum of the council getting together in some way with the intent to do county business. And intent here is very, very broadly construed. So if a quorum is talking about a county matter, that's a demonstration of intent to conduct county business right there. I don't think that anything more is needed to prove intent. Now, one of the issues is that it's not 1971 anymore. And so the courts have recognized that state agency business is conducted in lots of ways, including by email, by text, online at virtual meetings. Lots of different media are used in order to conduct county business. And not only is that allowed, in some cases, it's encouraged and required. For example, if we can do it, we must make council meetings open to the public via a virtual medium. So unfortunately, these other means of conducting meetings also pose some risk. So let's say that you have trained yourself not to hit reply all. And by the way, I will usually send emails to you if they are privileged to each one of you separately. So that is a mitigation. But let's say I send it to Counselor X, and Counselor X has some thoughts about it and passes that on to Counselor Y, who passes it on to Counselor Z, who passes it on to Counselor A. You get where I'm going? Everybody's in on the discussion. Well, that can be what the courts call a serial meeting or a chain meeting. And once again, if you're conducting county business in this discussion, if your discussion is about county business, you can't say, well, I didn't really mean to do county business. Well, then why did you? Don't do it. If you wish to respond, do it very individually. You might even talk to each other. But again, don't do a chain conversation. Or you might wait until, say, council time or a work session or something like that, and do it so that the public can know what it is that you're talking about. So next slide, please.
I have a question.
Yes.
I see here this case of Wood versus Battleground. It looks like it would be a serial meeting if the active exchange of information opinions is happening versus the mere passive receipt of information.
Right.
So if we get a really info-packed email that two of us received and it's good information, can we hit FYI and send it to the next person as just information gathering because it's mere passive receipt?
Well,
Double check.
it's passive receipt on their part. It's not passive receipt on the part of the person who's passing it along.
Even if it's a FYI?
That's passively sending. It's not passive receipt. However, my thought would be that if you are not responding to that in some way, that it is all right to send information on. Now, having said that, I believe that your emails are kept in this office? Yes, no?
You mean retained for
Yes.
later? They're on the system.
Yes.
So they're accessible for PDR. One thing that I've seen and I don't think is an issue, if you get an email that has a lot of good information and you want to have a discussion with council to say, sending this for information, I will be bringing it up during council reports so that it's very clear you're not discussing it and there'll be an opportunity to teach you.
Thanks.
So remember I said that a meeting is a meeting where action is taken. What is action? This is a key item. Action is enormous. It's the transaction of official business, including receipt of public testimony. So is what you're talking about receipt of public testimony? I would think not if it comes from one person. But it might be. Deliberations, discussions, considerations, reviews, evaluations, and final actions. So basically, if you're talking about it, other than, I think, just passing it on, then that's an action. And if a quorum is involved in taking that action, it must be done in an open public meeting. Final actions are also included in this. A final action is a decision. It can be generally done by vote. I've seen question whether they're final actions or not. Sometimes we ask for a thumbs up. That's a little vague, but I don't see OPMA issues about asking for a thumbs up from a quorum at council time. That's an open public meeting. Final actions must be done in open public meetings. So when you're having executive session, for example, you can't vote on anything. You cannot take a final action. All righty. Slide 11, please. So all meetings of the governing body of the public agency are to be open and public, and all persons shall be permitted to attend any meeting of the governing body unless one of the exceptions applies. Public agencies are encouraged to provide for the increased ability of the public to observe and participate in the meetings of governing bodies through real-time internet or other readily available means of remote access. And a number of these sorts of provisions were added to state law during the pandemic for obvious reasons. Next slide, please. So council must take public comment at a regular meeting where final action is taken. If you're holding a public hearing, the public must have the opportunity to comment on your hearing. in addition, we have other sorts of public comment that are not limited to what's on the hearing. And I think we have another slide that will address that. Next slide, please. So there are all kinds of different sorts of public comment. Some departments do work that requires them to have online portals to take public comment that is written, emailed, or posted. And some of those public records are massive. And next slide. There we go. 3 types of public comment. So y'all take public comment on consent and separate business, and this has a time on the agenda. And that's also the time, I believe, for open public comment, which can be on anything that is germane to county business. And that's a pretty broad category because, as you know, the county works in many aspects of life and community. So open public comment can encompass a great deal. And then each public hearing at a public meeting is for the purpose of obtaining public input. And so public comment is required at those places.
Just a real quick thought on that. I think it's important to remember that although I'm absolutely supportive of having open public comment, but open public comment is not actually required by state law. That is something that we as a council feel it's important to allow our citizens to speak on those things, but it is not a requirement. It is required that we allow people to comment on agenda items if there's final action being taken. So I think that's important for the public to remember that this is our attempt to really be able to connect and communicate with the public, and that's how we do it.
So my question is, when does open public comment apply? When does it?
That's on the agenda for the meeting and Tuesday.
Okay.
Well,
That's where you can
also,
comment on
isn't there? No,
For
Council-
just general open public
Okay.
comment, it's on Tuesday when they can comment on consent and separate business. On Wednesday afternoon meetings, it's only on agenda items only.
All right, next slide, please. So, council holds both public hearings and public meetings. Public hearings are a subset of public meetings. Hearings occur at public meetings, generally on Tuesdays. Council time and work sessions are public meetings, but they're not hearings. Final actions are generally not taken at work sessions, and public comment is not taken at work sessions, as Kathleen just explained. Public hearings are required by statute, by code, or by charter for some of the final actions by council. For example, state statute requires that if the county is going to give a franchise to some broadband provider to use the county right-of-way, that franchise be adopted by the county in a public hearing. And there's a rather elaborate notice provision for that. but that's a public hearing. GMA matters are decided during public hearings. Public comment is always taken at a public hearing, and there can be more than one public hearing at a meeting, and each one will have its own opening, closing, and public comment period. Meeting agendas must be posted online in advance of regular and special meetings. Executive sessions occur when council meets with senior staff and an attorney and without any public attendance. This is different from Oregon. I understand we got a question from a reporter who said, well, in Oregon, we get to go to executive session. Yeah, in Oregon, you do. That is not the state law here. And the public are not allowed in executive sessions. So prior to convening an executive session, the executive session must be done during a meeting, and the chair of the meeting must publicly announce the purpose for excluding the public. And those purposes are shown in the OPMA in RCW 4230-110. And there's a list of, I think it's A through Q, of possible reasons for holding an executive session, for example, to discuss pending litigation, for example, to discuss the price of real estate that the county wants to buy or sell. When discussing it publicly might affect the price, to discuss some personnel issues. So there are a number of reasons for having an executive session. Those are written on our agenda, so on your agenda, and they must be announced. And the chair must also announce the time that the meeting will reconvene. What if you talk too long? Well, that often happens, and we just send a signal out to staff who inform the public that the meeting has been extended until some later time. So the other item that must be announced is whether there will be after action or not. So for example, if a settlement of litigation is being proposed, that has to be approved by the council. So there will be after action at which open deliberation on that settlement, and then a vote will be taken. Sometimes there's no after action, but big thing to remember, you can't vote in executive session.
Just one comment. I remember before I joined the council, the executive sessions were a giant mystery. They're a big question mark. What happens in those executive sessions? And I can just say, 2 years sitting on this council, that has only been used for reasons that are valid by state law, but not only just valid by state law, but makes sense to our county as a whole and to the taxpayers. When we've had public comment, suggesting that some of these executive sessions should be public, that is not the case. In the event that the county has a legal issue, it is important that those deliberations take place in an executive session so that the taxpayers don't have to pay exorbitant expenses in lawsuits that we lose because we don't have our client attorney privilege
That's right.
needed to protect that information. So I think it's just important for the public to know that there is a very legitimate reason every time we enter into executive session.
And we aim to keep it that way. And for that reason, we don't go off topic on executive sessions. And sometimes, it's easy for these complicated conversations to lead to something else. And sometimes we will give you a kind reminder that that is not open for discussion in the executive session. And recall that the ethics statute that says that confidential information is confidential and it cannot be publicly revealed or revealed outside the context in which it remains confidential. So if you are privy to knowledge that is confidential, privileged, and you think that it is terribly important for it to be discussed in an open public setting, you can make a motion to waive the attorney-client privilege. And that motion would have to pass by a vote of 3 for the privilege to be waived. But that doesn't necessarily waive everything that you hear in executive session. So if somebody from Real Property Services is talking about the price of land, that's not going to be waived because the attorney-client privilege is waived. So they're kind of different things. A knowing violation of the OPMA can result in a lawsuit at which a penalty can be assessed against the violator or violators, and importantly, attorney fees, the big expense, can be awarded to the prevailing party. So, any questions on OPMA?
And if I could just add one quick thing on expanding on not discussing what's in executive session, don't even say which lawsuit we talked about, the topic. The topic should be pending litigation, not the specific litigation. So.
Right. Yeah, when I talk about executive session, if I were to send Kathleen, for example, an email saying, can we have executive session on Wednesday? I won't generally say about the Smith and Jones lawsuit. I'll say pending litigation or threatened litigation. And I'll give the statutory citation. I don't want it to even be in the subject line of an email. Okay, that's what I have on OPMA. If you have no more questions.
Okay, I think we're good. Councillor Belcott, you've been quiet there. Just want to invite you to say anything or have any questions on any of this.
Thanks, Chair. No, this is all just information I've already known about since this is going into year 3 for us. Thank you, though.
You're welcome.
All right, so we are now in public records. I would assume, if I were you, that any writing, any record of a communication or fact or anything that you have, use, create, whatever, in the course of county business can be a public record. Just assume it's a public record. Assume that it will be disclosed. And that should, once again, it's the front page rule. Do you want to see it on the front page of the Columbian? So, like the OPMA with its strong purpose statement, the Public Records Act is also very liberally construed, very broadly, strongly construed, and its exceptions are narrowly construed. So keep that in mind. Next slide, please. So there are three elements of a public record. It must be a writing. Remember, this is another blast from the 1970s. So records by and large were writings at the time, but that term has been widely extended to encompass modern technology. So metadata is a public record, for example. Sometimes we get requests for all the metadata regarding a particular matter, and that's something we have to respond to. So a public record is some kind of writing related to the conduct of government, and that is prepared, owned, used, or retained by the county. If it doesn't exist, it's not a public record. Every so often people, well, frequently, requesters ask for something that we really don't have, hasn't been reduced to a record form. It's not retained by us. Now, what if they want some bunch of information that can be very readily produced from a list or some other set of records that we have at the county by, sorting something on a spreadsheet, for example? That sort of easily produced item is generally assumed to be something that the county has. If it's something that requires, analysis and serious review to determine what's in it, no, I'm sorry, that's not something we have. All right, next slide, please. There are lots of requesters for public records who don't tell us why they want something, or we know why they want it and we think it's generally nefarious. That does not negate at all their ability to request and receive records. They don't have to give a reason, and it doesn't have to be a good reason. But their records have to be identifiable. And if they provide some kind of reasonable description of what they're asking for, then that's viewed as identifiable. Next slide, please. And the county is required to assist the requester in identifying and providing the records that they want. Public records law has become a much wider set of obligations within the past 20 years. 15 years ago, we did not have in the prosecuting attorney's office a public records department. There are 3 public records staff who are housed in the civil PA office right now who do nothing but respond to public records requests having to do with the civil office and criminal office. And you can imagine that has their workload has increased since the advent of body-worn cameras. There are public records coordinators for every department. Again, the need for these jobs did not exist 15 years ago. It absolutely exists now, and it can require a lot of work to respond to a significant public records request. So again, the county must assist the requester. And often that's by responding to the request by saying, what you said is such and such. I think that means you want this kind of thing. Is that correct? If not, let me know. Next slide, please. So the first thing is that when a public records request comes in, the county must respond in 5 business days. And by either providing all the records requested, by asking for clarification, by providing some of them and stating when the rest are expected to be provided after an adequate search. So the search is very important, and it must be calculated to uncover all of the relevant records. Again, records are presumed disclosable, but they can be provided in installments. And for great big ones, they frequently are. They can be disclosed by allowing inspection. That happened a lot more, say, 10 years ago, but people don't come into the county offices to look at their records very much anymore. They're typically put in some electronic medium and shipped out to them that way, though they can be printed on paper and sent out that way. So each department and including the county manager's office, has trained public records staff which performs these functions. Next slide. No one can be charged a fee under the Public Records Act for the inspection of records, and nobody can be charged for, this a chunk of the salary of the public records staff. They can be charged for copying. And back in my old life, when I requested public records once, I was charged $2 a page, which wouldn't be legal in Washington now, that's for sure. One of the issues with the body worn camera videos from law enforcement is creating and basically finding those video records, and the requester can be charged for that. So next slide, please. Personal devices and social media. Oh my. Communications on personal devices and social media can absolutely be public records if they are sent to or from you regarding county business. The best practice and our advice is to use a county email. Don't be using your personal email. Courts have required the seizure and search of counselors' personal devices for requested public records when the courts have found that the searches were not being done and the records were not forthcoming. You probably don't want that to happen to your phone. Use your county email and if you have a folder for it, put all your county business in that folder. If somebody requests items that might be on your personal devices, you will be asked to conduct a search of it and then to sign a statement saying that you have conducted a search and that you didn't find anything. And that's one of those, you want to be able to do that in good faith. So it's much easier to do the searching. If you use the county email, please use it. In addition,
One question on that real
Yeah.
quick. What I have done, because, you know, I think it's pretty much impossible when, you know people prior to you taking office. And so they know your personal email. What I have always done is whenever somebody's contacted me with county business on my personal email, I reply to them saying, you know, use this email address in the future. And I forward that to my county email. That way it's recorded in the county email.
that is totally the way to do it. I have done that myself.
Go ahead. Go ahead.
No, thanks for asking, for mentioning that. I mean, that's happened a couple of instances with my campaign email. So in a situation where we do advise the sender or we forward it to our work email, and we advise the sender that in the future they need to contact us, then that's, nobody can ask for personal stuff at that point, right? For a personal email, if it's been forwarded.
No, that's public records requesters tend to be extremely broad in their requests, many of them. I want everything that Councilor Fuentes has ever said about X. So they can ask for it. If it's not there, that doesn't mean that they can get it. And it doesn't mean that your device will be searched. If you have a practice that you have engaged in good faith, moving stuff over to your county email, and you are willing to sign an affidavit that says so. As to what the court's going to require if it gets to that, I am not a judge. I can't tell you, but those are, I think, the most effective ways to prevent an unfortunate decision.
Thank you.
You're welcome. In addition to disclosing public records, there are state requirements to retain public records, with different sorts of records having different retention periods. On the slide, you see a link to the state requirements. And some of those, you know, if what we're talking about is litigation, that can be, 20 years. So do not, here's another thing, put it on the county email and keep it. Next slide, please. So these are things that we've already discussed. If you have any questions at all, I am happy to answer them. If you think of a question later, let me know.
I do have a quick question. That last bullet point, if more than 3 counselors are in attendance, I know some of us attend, I don't know, galas or dinners, and as long as we're not sitting together, that's okay, correct?
What were you going to say?
I was just going to say, you can sit together. I think this is best practice to avoid having deliberation and discussion about county business. It's just a helpful tool for council to not inadvertently do that.
And it's not only best practice, it's OPMA compliance, I think. If you're sitting together and chatting about how great the soup was, that is not county business.
But it looks bad. The public doesn't.
Yeah,
It can
hard
look
to,
bad.
it's hard to prove that you weren't discussing county. I mean, you can't prove that you were or weren't, but it creates that environment where it appears to people that you might be. So it's just best to steer clear.
Great. Thank you. Any other questions? Thank you very much, Chris. This is
You're welcome.
very foundational information. Good for us to all be on the same page with this. I would just like to ask, since we've been going since 9 o'clock, if people would like to take a 5-minute break before we move on to finances.
Yes.
Yes, okay, 5 minutes then. We'll be back at 11 o'clock.